Hello, good afternoon, and welcome to our webinar on the 22nd of August 2022. We thought that with COVID coming to an end, we'll have more in-person sort of sessions. This has proven to be an excellent medium for engagement with broader of our colleagues and clients. And so we've retained this mode, despite the fact that we don't have to social distance, wear mask, sanitize, and show vaccination cards and the like. We're into what is colloquially called strike season. COSATU has indicated that it intends embarking on a Section 77 industrial action in this week. The public sector is on tenterhooks with a demand for a 20% wage increase. SARS has still not resolved its industrial conflict with a stop-start-go to their strike action. We've seen the steel industry embarking on immense strike and then industrial action, and then manage to resolve it. The question is, what do we do, and is there a way to deal with the industrial conflict our country faces, given the fact that we have a limited period of time in order to ensure that we're not put on the grey list? We have 10 years almost after Marikana, and we don't seem to have resolved the wanton conflict and violence that permeates our workplace, which mirrors what's happening in society at large. With me on our panel, we have Advocate Craig Bosch, who needs no introduction from the Cape Town bar. He has accolades an arm's length, and I don't intend to bore you, just to know that he's a superb counsel who we rely upon heavily. We then are honored to have Advocate Luvuyo Bono, who is the chairperson of the ESC, and under his watch, a number of commentators have indicated that he's revolutionized the ESC by dealing with aspects and tackling them which have not been dealt with for a considerable period of time. And then obviously my colleague Imran Mohammed, a thought leader in the field. And what we intend doing through this diverse panel is, as a discussion between Imran, Craig and Luvuyo, with me interjecting every now and again, firstly setting the scene as to what is happening in our country from an industrial relations perspective, and at least from a conflict perspective. Craig then offering some sort of insight as to whether private arbitrations may be a way to resolve this, and what's the pros and cons, and how does one go about it. And then Advocate Bono providing us with insight and lessons from the ESC, which may mirror any sort of compulsory arbitration to resolve industrial conflict. We have you for 90 minutes. You may put whatever questions you have in the chat, and we'll filter them through. I wanted to start off with Imran and just tell him to set the scene from a industrial relations perspective and what the courts have been saying about the wanton violence and whether the interdict process is actually worth the paper that it's written on.
Controversial question, Adi. Perhaps let's answer the question in relation to essential services specifically. We've seen in recent times, with the scars of Eskom behind us over the last couple of weeks, where there was unprotected strike action at Eskom, a designated essential services entity. Employees go out on an unprotected strike. We've seen what the consequences of that has been for the country. Prior to that, we've seen in the health sector a a number of employees over a number of years in the public service disregarding the essential services designation and going out on a strike. Now, it begs a question as to, well, what is the effect of those employees going out on a strike in an instance where you have a designation? In my view, employees do it because they know there's very little consequence associated with not going out or in going out and returning back to the workplace. Employees, I will either expect that on their return to work after the picket line, that it's going to be a case of receiving a warning and potentially a negotiation of some sort in respect of no work, no pay, or at least receiving some form of payment. The difficulty that we've got in essential services, obviously, is that where employees disregard the essential services designation, we know the actual consequences for society at large. I mean, there's harm potentially to life, there's a life or health of individuals as a consequence of that. So in my view, what needs to happen is a lot more than an interdict. I think our law needs to be pushed forward in relation to, at the very least, I would say, a criminalization of any employee that goes out in contravention of a designation. At the very least, I would think that's a starting out point. The concept of non-compliance with interdicts in the private sector, we're all familiar with that, and the rigmarole that is associated with giving effect to those interdicts once employees are interdicted from unprotected strike action. That's an entire story of its own. So to answer the question, Adil, quite in a very lengthy form, I think we need, especially in essential services, a shakedown in the law. My own view is that this conduct should be criminal. Employees that go out on this form of action in the public service should be criminalized. And at the very least, the law should be developed to the point that employers may not pay employees who go out on an unprotected strike in essential services, because we're on a slippery slope if we don't arrest this current development that we see.
But I gather that the issue is not only focused within an essential services environment. It's wanton, it's throughout industry generally, where employees believe that insofar as they wish to achieve an objective, they need to embark on strike action. They need to embark on industrial action, which is of a violent nature. Maybe just to get Craig in here. So Craig, one of the things the topic actually identifies is the way to deal with industrial conflict is through private arbitration. And I guess because it's a mutual interest issue, it would be through private arbitration. And if you could just unpack whether that may potentially be a solution, at least in industries which are non-essential for now. Thanks.
Yeah, thanks, Adil. I mean, I just as a general point, I'm not so sure how productive it is to introduce further sanctions in respect of people that strike in essential services, and perhaps that's something we can debate. I mean, as you know, the sanctions are many. I mean, you've got potential discipline and dismissal. You've got civil damages for individuals and for trade unions. You've got court orders and interdicts and contempt applications, costs orders, and these things are just haven't worked. And it's an interesting question whether a criminal sanction would add anything in terms of preventing people striking when they shouldn't. As far as private sector employers are concerned, I think there's quite a significant benefit in introducing private arbitration to resolve disputes as opposed to employees embarking on strike action. But that's something that unions and employees would have to buy into. I mean, the obvious benefits for employers are that people don't go out and strike, and you don't have the economic pain that comes with that, and the potential violence and destruction that might accompany a strike which gets out of hand. And to get employees on board, you'd have to, I imagine, be able to persuade them that there's something significant in it. So first of all, I suppose as far as the outcome is concerned, that they're likely to get something by way of a private arbitration that resembles or is, if not, is better than what they would get via industrial action. And just on that point, I mean, international experience seems to suggest that in general, and perhaps this is something which is reflected in South Africa too, and perhaps Luvuyo can talk about that, that in general terms, employees that refer disputes or disputes which are referred to private arbitration as opposed to being resolved by way of industrial action result in an outcome for employees that is essentially the same as what other employees in the industry would have gotten by way of strike action. It means that employees don't lose working days, because obviously if they're out on strike, that's unpaid. And arguably, at least, there's more control. Now, certainly there's more control over that process as opposed to what might happen in the course of a strike. So it's open to the parties. If you're going to have your interest disputes, your wages, working conditions type disputes resolved by way of arbitration, it's open to parties to set the parameters in which that dispute can be determined. So you can choose your decision maker. You can choose the principles that they apply to make their decision. You get to determine perhaps the timeframes within which disputes must be resolved, because certainly my sense in the public sector, in essential services arbitration, is that there are concerns around the time which has been taken to resolve disputes. I mean, there's one example where the dispute took 7 months or so to be arbitrated in the end, and by then you're into the next wage cycle, and it really doesn't serve too much purpose. So there are potentially advantages and also certainly some drawbacks.
But I think just before I go on to the chairperson of the ESC, is I gather that the one difficulty with interest arbitrations or private arbitrations is that you need to justify whatever offer you're providing, and that would mean opening up your financial records of an organization that may not want to do so, whereas in industrial action, they don't need to, and therefore there's this balance between, do I take violence or do I open up my books of account? Well,
I suppose it's an interesting point, and I think it depends on the process that you're adopting in your arbitration process. You could say to the arbitrator, well, we want you to make a decision based on principles of fairness, whatever that means.
Yes.
And then you've got to lead evidence, and that might include opening up your books to show, look, we really can't afford more than A, B, or C. Alternatively, you do a kind of final offer process, where you say, well, you know, the sort of arbitrator looks at both parties' final offer and determines something somewhere in between, and that doesn't necessarily involve leading evidence about what's in your financial records. So that might be a concern, but there are ways of mitigating that depending on the process you elect to adopt.
Yes. Thank you, Kleke. Maybe just to now jump onto Advocate Luvuyo Bono, just from the ESC. And Luvuyo, maybe just for the audience, just to set out, what does the ESC do? And after the Supreme Court of Appeal judgment, how did the legislation change to make your lives even more difficult than what it was? Thank you.
Thanks, Adil. Mainly we do three things. The ESC designates services as essential, and once a service is designated as essential, employees who render that service, their right to strike in terms of Section 65 of the Labour Relations Act is limited. So that's the first thing that we do. The second thing that we do is we ensure that in those services that are essential, there is what is called minimum services to be maintained in the event of a strike. So because if this particular service that's been designated as essential means that it cannot be interrupted to a point where it collapses completely, that we have to make sure that there are minimum numbers of employees that still continue to render the service. Albeit that some of the employees will be participating in a strike. So we do that in two ways. Employers and employees can negotiate and agree on minimum services, or we determine the minimum services for them. And then the third issue is disputes. We then, in terms of Section 73, resolve disputes in essential services. We also have another one in terms of Section 75, which focuses more on maintenance services. That's where there's a likelihood to be a destruction or endangerment on machinery. So that's in a nutshell what we do as the ESC. Part of what we also do is that we sell interest arbitrations as an alternative as a real alternative to participating in a strike. But we certainly think that the balance that having an MSA does, if it could just be done orderly, if you can have an orderly strike with an orderly keeping of minimums, you can have the best of both worlds. Some years ago, I wrote an article to the COSATU newsletter because it was taking quite a long time for unions to internalize that you can actually participate in a strike and at the same time, so you can have a strike and you can have some of you ensuring that this service that you are rendering, which has the potential of endangering life, personal safety or health, does not cease completely, that it continues to be rendered. So that's essentially what we do, Adi.
Thanks, Luvuyo. But I know that for a fact, and just then to link onto what Craig was saying, that as to how we cater for interest arbitrations and the negotiations that we look at. There was a Supreme Court of Appeal decision regarding on the ESC.
Yes.
And there were subsequent amendments to the Labour Relations Act as to the identification of people who are part of the ESC and the like, and whether those have posed any real challenges in the determination of the conclusion of minimum services agreements and designating entities as essential services.
Yeah. Well, let's start with we now have a clear test. And with let's start with the subs and Pope Crude judgment, which has reinforced the concept of restrictive interpretation of essential services. So what that does is that it says you have to look at people who are rendering essential services, not a support service too. For an example, if we talk about traffic in a municipality being an essential service, the lady who cleans at the traffic department and the lady who makes tea for the traffic officers, they're not rendering an essential service. The people who are rendering an essential service are the officers, the traffic officers, the people who are rendering traffic services. So that's the most important part. And then you come to the ESCOM judgment. There's a confusion about where these disputes should be handled, whether they should be handled. MSA and they should be conciliated at the CCMA. But if you read that judgment, it's quite clear that the court says it is only, in fact, the SCA uses the words only, the ESC that has jurisdiction to determine the minimum services agreements and minimum services determination disputes. We have, and I want people to understand, we've had great success in minimum services, and for us it's a starting point. Before the amendments, we had four minimum service agreements in this country. Today, as we stand, and I asked the manager at the ESC to give me the latest stats, we've got 219 minimum service agreements, which is a success for us. And we monitor these. Whenever we hear there's a potential strike, we you know, we go out there. Yes, there's been success stories. There's been stories where there's been some degree of compliance, some non-compliance completely, but it's certainly a starting point for us. There's some achievement there because it's the unions that have negotiated and agreed to these minimums. And the next step is now to move them to a compliance to a compliance step, and Craig talks about too many compliance, too many compliance issues, and perhaps not criminalizing, not criminalizing a unprotected strike, but certainly there's a need to find something that's effective, because what we have currently is completely ineffective.
Thanks. And to Craig, so having noted what the chairperson has stated about minimum services and how they've classified services as essential, do you believe that the lessons and the successes can be replicated for the private sector within the collective bargaining environment, utilizing case studies from the ESC?
I'm a bit torn, and again, I think I'd appreciate input from all of you too. On the one hand, I like the idea of employers being able to negotiate with their employees that in order to avoid the sort of the destruction of the enterprise in a non-essential services context, that certain workers are designated as a minimum service, and they're then precluded from striking, whereas the rest of the employees can. The difficulty with that, I imagine, would be selling it to the employees, because what you're saying is you're trying to keep from striking the very people that are going to be the most effective in striking. And that fundamentally curtails the power of employees who want to strike to get what they want. So I imagine, while I like the idea in principle, and I'm sure many employers would, I think it's going to be very difficult to sell that to employees and trade unions in a private, non-essential situation. One way of doing it, perhaps, is to give workers a sort of an incentive or a premium in their remuneration. You work in a minimum service in the organization, you earn X amount extra. As a result, you sacrifice your right to strike. We get the benefit of keeping the organization, at least to some extent, going. Everyone else can go out and strike and then see how far that gets them. Like I said, I think that would be a difficult sell, and I don't see that being particularly successful in the private sector context. But my sense is that a better idea might be to say, look, let's sell interest arbitration more broadly, and so that everyone agrees that they are subject to arbitration when it comes to interest disputes, and we all reap the benefits that come with that, as opposed to trying to designate a minimum service within a private sector employer. And again, it comes back to the potential benefits of interest arbitration, and what are you going to get out of it that you might not get if you go out on strike.
But I think from an employer, maybe this will just lead on to my next question to Imran. We have a problem in South Africa. Our strikes are simply too violent. And what do we do in order to deal with that? And I think that's the big issue. So I understand about the reluctance, but I think from a country perspective is we need some sort of solution to the violence. And to Imran then, given this problem, why are private sector employers reluctant to go down this road?
Well, I'm partly in agreement with what Craig says in relation to designations in the private sector. I think we'll have a fair bit of difficulty on that front. But can I perhaps try and answer the question in a lopsided manner? I've been doing this about 20 years, and I remember when I started out doing employment work about 20 years ago, just as I got into it, in the private sector, I recall being involved in at least 2 private arbitrations, interest arbitrations in the private sector. And in the 20 years that I've been doing this here, I've seen 0 to non-existent interest arbitrations in the private sector. Now, that begs the question, Adil, what do we do with the violence? So maybe being philosophical about it. In the 95 amendments, perhaps the intention was that under the current labor relations regime, because you've got the constitutional right to strike, that's going to be the weapon that's going to force employers to come to the bargaining table. Perhaps that was the intention. But we've seen that that hasn't in reality borne fruit always for employees. Strikes are accompanied by the violence, destruction to property, and generally a serious negative consequence either for an industry or for the economy at large. We've seen that in the mining industry over the last couple of years. So unless employees are able to go out and strike and couple that with destruction of property, general lawlessness, they don't see that the right to strike achieves the objective. And this is where I think private or interest arbitrations potentially becomes another factor or tool in the toolbox for breaking down the deadlock, and at some stage in the collective bargaining process becoming relevant. But it then begs a number of questions as to why employers in the private sector wouldn't want to venture in that direction. But perhaps we can debate it a bit later.
Before I take Professor Pienaar's question, just to Luvuyo, there's a chat, there's a question, in your experience, how successful how meaningful has a designation been to protect strikes from occurring within an essential services environment, and with reference to MSAs, based on what we have seen, what you in your capacity of experience. So within an essential service, you have people that have minimum services agreements. I know that at Eskom, they cancelled the MSA and now the entire organization is regarded as essential. And whether the designations, we know the Eskom example, but just over the years, have they been successful in averting industrial action generally and sort of wanton violence within an essential services environment? Thanks.
It's really a mixed bag. It's a mixed bag. We've had cases where there's been 100% compliance. Some years ago, traffic in Joburg Metro went on a strike where they 100% maintained the numbers, the minimum numbers for the entire strike. The strike was over a period of 3 days and then it was resolved, but there was full compliance. We had a strike in UNISA, remember security in tertiary institutions is designated as an essential service. We had a strike in UNISA. In fact, we had 2 strikes in UNISA. The one strike, the securities joined the strike and they went on strike. We went there, we addressed them. There was another strike a few months later and the security services they didn't even, it was not even a question of them maintaining the numbers. All of them were worked, so they did not participate in the strike at all. So we've had a mixed bag. We've had a mixed bag. Most of the sectors where we have MSAs is your social centers. Those hardly go on strike. Municipalities, there's been very few strike in municipalities in the past 2 to 3 years. It's probably a handful of municipalities, and those we've those are the troublesome ones, which tend to have one or more strikes a year, and some of those ones are really where you've had you've had non-compliance. But it is a mixed bag. I mean, it's a mixed bag.
But just on that, Luvuyo, is that I've seen, and so sorry to the professor, just while I have you on the line, but there's certain, if you look at the government gazettes, been a substantive increase in the amount of requests for services to be declared essential. And in your view, what would you attribute the increase to, apart from the fact of the ESC's efficiency, and people are looking at a department that's so efficient and they believe that they can just flood you? What would be the other reason in relation to that?
Well, I do think that employers generally, and I don't mean this in a bad way, I think generally employers try and avoid strikes as much as they can. And if there's an alternative to allowing employees to go on a strike, employers will explore that. We have, I mean, we chase away some quite a number of excuse me, requests for investigations that are sent to us. So there's a fair number that we decline to investigate. We investigate those obviously where we think if there will be an endangerment to life or personal safety or health if that service is interpreted. But there's a lot of them. I mean, there's a lot of services that can be considered. Remember, Adil, we also, one of the sections that was introduced is that we do self-initiated investigations. And self-initiated investigations, what we do, we look at the ILO digest, we look at what the ILO has considered to designate as essential service in the past, few months, and we do likewise. We've done a number of those investigations where we've been guided by what the ILO is currently looking. I mean, currently, you would have seen tomorrow we're starting with investigations again. We're investigating disaster management, and that's a self-initiated investigation. It's an investigation that nobody has referred to us.
Thank you. Hugo, comment, question?
Yeah, thank you, Arnold. If I may just make a brief comment. Thank you, Luvuyo, and thank you. It is great to have your positive input where it has worked well. And I fully support the idea of where we can get employers into private arbitration and avoiding a strike. That would be the absolute first prize. So I'm absolutely with you on that. But of course, we know that when you advise employers, they'll only agree to that if they know they're going to win win, quote unquote. And that would mean that you would normally look at a final offer arbitration. And the final offer arbitration does not always suit the union's approach. They would want more of a generally a fairness outcome and not the last offer or a final offer arbitration. I think the concerns that employers would generally raise is that if you look at the ESCOM scenario, they have all the protection. In fact, they had on top of that additional protection of the military and the police. Why did the unions follow the violent option? Well, as Van Niekerk stated, often employers rather settle because of the violence than for commercial considerations. And I think that it's a discussion that we really need to have with trade union leaderships and to say, we need to address, and the points have been made, to address this alternative to violence and what, the lessons we've learned from that. And of course, once we get employers to move into this concept and unions agree, and the first loose quote unquote for unions on a last offer arbitration may cause them to be more suspicious about the process again. And then we have the other concern often, and if you could guide us on that too, is that often a decision to strike, and that's really maybe a subjective perception, is that, and again what Mr. Jim said earlier this year, the decision isn't about the worker mandate, it's a political decision or where the trade union or its leadership finds itself at a particular time, and that determines then a strike or no strike. But in short, I don't think one should just focus on the negatives. I think if we could have people voluntarily joining unions and employers on arbitration as opposed to, and have a third party deciding as opposed to the power play, which doesn't really work, that would be a win for everybody. But I'm afraid that's maybe too much of an employer's perspective. Thank you, and thank you for your positive input, and learning from Eunice. That's certainly good news to hear. Thank you for that.
Thank you, Prof.
Craig, can I just ask you that I know that out of most of the statements made, you seem to be lukewarm about private arbitrations being the panacea for violence. So you have an employer, private sector, they're not an essential service. The investigations, as Luvuyo has correctly said, they've kicked out a number of investigations. The normal vanilla sort of interdict doesn't work, where you simply go to court and say interdict everyone. In your view, what would be some of the other creative options that a proactive HR or IR practitioner or head of legal takes or starts considering in order to deal with the violence as such?
I'm not so much lukewarm on interest arbitration as an option. I think it would be fantastic if that was the way in which interest disputes could be resolved. My concerns are whether it's realistic in the sense of it being something which could be sold to employees and trade unions. And I mean, perhaps then to answer your question, something that employers or HR people could do is to do some research and some investigation into sort of interest arbitration best practice, and that whether that's sort of local and or comparative, and in order to be able to go to trade unions and employees and say, look, this is what we're proposing. These are the benefits for us, and these are the benefits for you, and and they're in all likelihood significant. There is also the broader elephant in the room, which we've sort of touched on but haven't really discussed, because maybe it falls without the parameters of this discussion. But that's the factors which influence adversarial workplace relations in this country that are not resolvable necessarily by an employer, but impact fundamentally on the lives of employees and perhaps drive a lot of the sort of adversarial conflictual relationships in a workplace. And those are the sort of broader socioeconomic considerations, unemployment rates. Hugo mentioned the sort of politics in trade unions. So that all of those things too that have an impact here, and how one starts to address the broader problem around adversarial relationships in a workplace is a fraught question and a very difficult one. The glib answer would be to say, well, you do what you can do in your workplace, and I don't know what those things are. It depends on your resources, financially and in terms of your expertise, and perhaps a selling point of interest arbitration is to say, look, we've got to get to a point where we get along, where we can cooperate, at least notionally. And one of the ways in ensuring a smoother path is to say, well, let's try interest arbitration. We both have an input into how the process unfolds. We both have an input into the principles which are taken into account in making decisions. We both have an input into who the decision maker is, etc., etc. Here's the comparative research. It's good for you. It's good for me. Let's start there and commit ourselves to this kind of process as some, maybe not so small way of alleviating an adversarial connection.
Okay, just on that, before I move on to Imran, but we're 10 years after Marikana. And the question that you have to ask yourself is, what has changed in the industrial relations environment? And maybe just that open question to you and Imran. And yeah, so what has changed in our industrial relations environment? And my view as a practitioner is absolutely nothing. It's still adversarial, it's still aggressive. And I'm not sure that private arbitrations, even as a means, and how you posed, I understand it needs to be by agreement, that we are going to obtain that sort of agreement with the minutiae that you're proposing. or which mirrors what the ESC has said, just given our industrial relations environment. But that's an open question. Let me just leave that to you, Imran, to answer.
Well, perhaps I can just start before Imran gives us his input. I mean, I agree, and as as I said, it would be a tough sell to say to employees in the current context, give up your right to strike and come and sit down around an arbitration table. It would be tough. But the question is, how do you sell it? How do you say to employees and unions, this is what's in it for you? Let's do this, as opposed to what we've been doing up until now. And just to come back to the point that Imran made right at the beginning about there being a general disrespect for the rule of law in this country, and this is why I think essential service workers feel it's appropriate to go out and strike, because there's no comeback. Violence is commonplace in strikes because there's no comeback. And again, it's a sort of carrot and stick approaches. You disincentivize conduct which is unlawful by strict measures, but you also need to incentivize compliance with the law, and perhaps we can focus on both. But those are things we need to be thinking about. How do we diffuse the current adversarial climate? Sorry, Imran.
So Craig, perhaps let me start out with an article I'd read written by Chris Albertine. I think it was about 2013, as I was preparing for this talk, or for this discussion today. And he refers to this concept by an academic by the name of Rose. I'm not sure if she's Canadian. And she says that interest arbitration has, and I quote, a corrosive and narcotic effect on bargaining, which I think is fantastically put. Because essentially, once there's an interest arbitration at the end of the tunnel, parties almost instinctively, instead of genuinely engaging in a bargaining setup, in order to get to a point of reaching an agreement, position themselves for the ultimate arbitration. So it is the give and take. The difficulties, I'm in agreement with you, the sell to trade unions in relation to giving up the right to strike in order to walk into a private arbitration is not easy. And likewise for employers. But that having been said, to Adil's question, what has changed over the last 10 years? I'd say what has changed over the last 20 years, where we had these grandiose views in the mid-90s that the landscape is going to change significantly because the country is changing. But the country has changed not only politically, but the country's changed economically very, very seriously. And all of those socioeconomic factors, as you correctly say, impact on workplace issues. So perhaps the Canadians have some sort of a mechanism that we can borrow from. In their public sector collective bargaining setup, they've almost got the Section 150 process that we've got since our last amendment, but on steroids. In the sense that it's not a you kind of make an application for interest arbitration. It's almost foisted upon you at the stage where government believes that it's necessary. So collective bargaining parties always run the risk of an interest arbitration being foisted upon them if they don't come to an agreement. So what do we do in the private sector? My thinking would be probably twofold. In the absence of legislative amendments, you'd have to get parties around the table, but it would require a very changed mindset. Not easy, but perhaps in the right environment, it's something to be considered. And if you've got mature parties on both sides that see the benefit of it, perhaps it's something to be done. Perhaps in a collective agreement, provision is provided for the right to strike, and there's almost a limitation in relation to the right to strike that says at a point where the strike becomes violent or has gone on for a period of time, then the parties are obliged to go into private arbitration, private interest arbitration. So there isn't an abandonment of the right to strike. There's a limitation on it, and the union can push hard on the right to strike, and it self-regulates violence on the picket line and everything else of the sort, and maybe that avoids a private interest arbitration. And if that doesn't bear fruition, you get into an interest arbitration. Perhaps that's one mechanism. Alternatively, it's the legislative amendment, where government says it doesn't have to be in the public interest. If a strike is on for a period of time, you go off to the CCMA, and the CCMA must have an interest arbitration in order to bring the parties to the table. And the points that the Prof makes are valid points. Then it becomes a question of what form of private arbitration result ultimately carries the day, but that becomes a legislative choice in the consequence of not concluding a collective agreement between the parties. So it forces both sides to take positions quick in order to bring industrial action to a quick close. So it's a long answer, Adil. Not much has changed, but I think we're moving very quickly, or we need to move very quickly as a collective, as an industrial relations within the environment to a different scenario than we currently exist in, because this year is slippery slope.
But can I just take, and probably if you could come in here, but just take some sort of, if one looks and reflects, when I sit and I think about what has happened 10 years after Marikana, is certainly there's been more creative lawyering, where what happens is you're having employers compelling SAPS to take action now, and there's a case where when they haven't, that's certainly a way to compel them to do so. There have been avenues where strikes have been, protected strikes have been declared, have been suspended pending the provision of a report on violence. There's the threshold for when a lawful strike moves into an unlawful because of the level of violence, but certainly your approach is quite endearing, where there's a threshold for violence which moves into an interest arbitration. But I want to just start with Luvuyo, where what we're finding at the ESC is there have been a number of applications that I'm aware of where so-called support services have been deemed to be essential. And maybe if you could just touch on what do we mean by those support services as such. Now, maybe you just want to touch on while we was coming back on from your experience, just sort of the applications you're getting in relation to a support service, and maybe that is a way to deal with the sort of wanton industrial action. Thanks.
Yeah. Thanks, Adil. I think let me use the opportunity also to assist parties who might want to make applications to us. When you make an application and there are other services, call them support service to the service that you want to, we prefer that you include them. So let me give you a practical example. We designated health services, and health services, it's health services and emergency health services. But then under that designation, you have support services, which are catering in hospitals, cleaning, and all other services, a long list, about 17 of them. But if you come to us and say health services, we're going to focus on what you give us, investigate that, and decide whether we should designate that or not. And we do not go between the boundaries that you give us. So it's important that when parties want services linked or services that support the service that they want, that they include that in the arbitration. So I'm sorry, they include that in the application so that we can investigate those as well. So that's how essentially support services work. Adil?
Thanks. Sorry about that.
Sure.
And then just to come onto that. So Craig, we don't have support services. We can't designate you as essential service and therefore can't go to an interest arbitration. Given that the sort of, I don't know whether clever lawyering or the ways that which interdicts are sought, what in your experience has been the enforcement mechanism of any interdict secured by by employers? And the follow-up question on that is that on Imran's thing is, I know the court grapples with the threshold for violence, whether that would be a potential solution. If parties can't agree that you go to interest arbitration, whether you go to court, ask them to rather send it to the ESC who has experience to deal with these sort of interest sort of disputes, or at least determine who can go out on strike while you in an interest arbitration.
I'm sure you know as well as I do, often that the remedy for enforcing interdicts is contempt of court applications, or if they've been ordered to help, going to SAPS and getting them to come and step in and do some crowd control. I mean, there have been cases where there's been more than one interdict issued against striking employees, and they've simply taken them and torn them up and carried on with unlawful conduct. I like the idea that Imran was talking about, this notion that you get to a point where a strike needs to move from, or a conflict needs to move from a strike into some other form of resolution, like mandatory interest arbitration. And that's something that's going to have to come by way of legislative change. And we've got the model in the essential services sector. And the question is whether the legislature would be amenable to introducing that in the private sector. And that's going to give rise to any number of challenges around limitations on the right to strike, etc. And I'm sure the Canadian example is perhaps a useful one to draw from. I think it would be a hard sell to go to a court and say, well, we think as an employer that things, I mean, in terms of the legislation as it currently stands, and that's what I understood you to be suggesting, that it would be helpful, it would be beneficial to direct parties to go and consult around or consider some kind of minimum services agreement within their organization, to seek the guidance from the Essential Services Committee. That I don't think any court is going to jump at that anytime soon. I was wondering whether there's any role for advisory arbitration in this context. I noticed it was something which was mooted at one point, that the CCMA could get stuck in and say to parties, you must submit yourselves to advisory arbitration in relation to your interest issues, when in those sort of big disputes where it's considered to be in the public interest. And I was wondering if there isn't some sense in putting a mechanism in place where even at a smaller individual employer level, that might not be an option, either by agreement or something which the legislature introduces and says, look, we're not going to force you to go to binding final private arbitration, but we require you to submit to advisory arbitration with whatever sway that brings in resolving a conflict.
Yeah, and I think all of these, and I think in the next short while, I'd like to just focus on this here. At least we've identified the problem. We have violence, and we don't know how to deal with our industrial relations environment because it's quite adverse. We have success with the essential services, designating services as essential, designating support services, managing minimum service, and that's all legislated. But everything that we speak about now talks about a partnership with the trade unions, and maybe to pontificate and look through whether what we say is actually achievable and whether we've moved within our current industrial relations environment to a situation where we could have those meaningful discussions, noting that we have a split from COSATU, we have the Trade Union Federation, we have AMCU being born 10 years ago, whether our industrial relations environment is sufficiently mature to achieve this through engagement. And I know Imran's resolution is legislative, but whether from your view, Craig, whether we are at the stage, and if not, if you have to give advice to our clients on the call, how do they get to a situation where they're able to have meaningful engagement with the trade union so that they agree sort of a set of rules which does not seem where we have huge financial losses as such?
You're putting me on the spot here, Adil. You're asking me to answer an impossible question.
That's the point, right? and maybe Luvuyo and Imran has been engaged in it, because I have a view that I think what we do is that we try and impose sort of principles from the ILO, and that we're not yet at a level in our industrial relations environment at that stage. But I'm mistaken. Luvuyo, Craig, Imran.
Let me start. I agree. I mean, I think it is a question of the relationships being mature enough to even start negotiating around things like interest arbitration to resolve interest disputes. And you know, it's the starting point is addressing that issue. And I'm no conflict resolution expert in terms of facilitating processes in the workplace. I'm not an HR person, and I'm not an expert in managing relationships. But simplistically, that seems to me to be the point of departure. Is how does one cultivate not a sweetheart relationship, but how does one cultivate a sensible relationship with your trade union or your employees if there's no trade union? And again, simplistically, it seems to me that your starting point is let's sit down and look at how we've been connecting in the last however many years. So you can take 10 years and see how relatively unproductive it's been. And aren't there ways in which we can make this better for the business and for the workers, and have a kind of relationship by objectives exercise and plot your way forward, starting very simplistically there. That's my sense. Maybe the others have a better suggestion.
Yeah. Let me come in. I'll come to the question now as last of my issue, but I just want to touch on two things that have been mentioned before. Adil asked the question, what has changed in collective bargaining after Marikana? I agree with you, Adil, nothing. And I think legislation has let us down. I think the drafters of the Labour Relations Act have always been extremely concerned with individual employment law. And if you look at the set of amendments after 95 to 98 to 2000 to 2002, there's always been amendments on individual employment law and not on collective bargaining. And we are in the mess that we are in because the legislators have just not paid attention to collective bargaining. The reality of it is that we're sitting in a situation where even unionism is going down by itself. You know, so it's not just employers who are in trouble. Generally, unions are in trouble because the numbers are not what they used to be. But coming to the issue, there's a concept in the US that's called collaborative partnerships. It's built on the same concept as what Craig is saying, which is a relationship building exercise. But it goes further. It goes further in that it also involves unions in production, it involves them on the vision, mission, the operations of the company, what the company seeks to achieve at the end of the year, and whether it achieves or not. If it doesn't achieve, what are the implications on salaries and so forth. So it's a more, they call it collaborative partnerships. It's a more value-based relationship with the union. It's still currently being piloted. I mean, it was introduced by a guy from Rutgers University in New York, and I speak to him a lot because I'm quite interested in the concept. But where I want to get to is that I think for the benefit of HR, ER, and IR people in the webinar, there is obviously a greater need to have a relationship with the union and to have a value-based relationship with the union. I think it's a start. I think it's a start. It puts you somewhere, and from there onwards you can build. We're obviously worried about the distraction, the violence, and everything. But equally, I think that we have seen less of those where the relationship is not that bad. Yes, you will still get the unprotected strike, but I'm a believer of building in blocks. Creating a foundation and then building from there onwards to finally achieve what you want. But those are my views.
Thanks. Craig, there's a point from Ibrahim. I don't know whether you can see the chat, just his comment, and whether you would like just to comment on that. Ibrahim's from Mediate Works and a consultant firm as well, but just on advisory arbitration there. So there seems to be a challenge from a negotiation perspective in obtaining mandates, and how best, if you just like to comment on his thing, if you can. So maybe I should just ask him, Ibrahim, do you just want to articulate the point and just join the discussion? Thanks.
Yeah. Look, I take that point. I mean, I've just read it
quickly. No, that's fine. I just want to see if he's still here. Thanks.
I've allowed your mic. You should be able to unmute now.
I think there's we will get him we'll get him on the stuff in a moment. But I think that just from Imran, do you have any comments on what Luvuyo has just said? The sort of engaging in a more collaborative manner with trade unions as a way to resolve industrial conflict, as opposed to looking at a dispute resolution solution as such. Thanks.
Yeah, look, I'm in agreement with Luvuyo on 2 points. The one is in relation to the lagging behind of legislative amendments on collective bargaining. Now, I think the classic point, or the classic example of that, is the SCA judgment that you were referring to earlier, Adil and Luvuyo. I mean, a matter of that sort shouldn't have required the intervention of the court on an interpretation issue, when the legislature could have simply amended the legislation at an earlier stage. I mean, it went to determining the powers of the ESC as opposed to the powers of the CCMA in dealing with essential services. So I'm in agreement on that point. On the second, in relation to collaborative workings with unions and relationship building, I can't disagree with that. I think the one advantage in relation to this is not an ESCOM fault. This is saving so it's got nothing to do with unprotected strike action. The COVID And when the lockdowns occurred, for me, in my mind at least, was a watershed opportunity for changing of dynamics in relation to relationships with unions. What I'd seen in my practice is employers that had a reasonably good relationship with their trade unions were able to come to solutions with them very quickly in the very early stages of the lockdown, in order to determine how are we best going to manage the situation, in not only in the interests of union members, but in the interests of the enterprise, so that we get to survive this. And obviously there were fair bits of fights and like around that, but the vast majority of successes came out because of relationships that were cultivated in times before COVID. And I think where companies and unions are able to cultivate that going forward, it's in the interest of capital and labor.
So I think where we've landed up now is probably a couple of solutions. We know that we have the essential services, and within that we have minimum services and then potentially support services. Within the private sector, we have interest arbitrations and potentially private interest arbitration, but to be regulated as to the terms of reference and what it would be from there. But I think in the absence of legislation, we need to go back to, and maybe this is where we can just start unpacking, especially from Luvuyo's side and Imran's side, the sort of relationship building and trust between trade unions and employees. And the question that I posed to both Luvuyo, Imran, and probably Craig, you from a litigation side, is how do you build that sort of trust where you have a decimation of the trade union movement? You have NUMSA's Congress being interdicted. You have, and I know this is on appeal, but you have AMCO being charged, well, the Department of Labor seeking to deal with it because they haven't filed annual financial statements. And I know that judgment's on appeal. You have the Trade Union Federation, and is it actually worth it for employers to start investing in that in a situation where we have the sort of internal strife or strife within the trade union movement? Craig, Luvuyo, Imran.
I don't see that you have too much choice, truth be told. I mean, if you have a workforce which is represented by a trade union, problematic as it might be, I would imagine that establishing some kind of decent relationship with those who are on the ground as representatives of that trade union and in your workplace representing your employees is fundamentally important. I take the point that happens against the backdrop of general chaos, but sometimes in the broader trade union. But perhaps that need not detract from the engagement that you have with representatives of that union in your particular workplace. I just wanted to go back to the point that Ibrahim Telia was trying to make, and as I understood it broadly, he's saying that there's a need to revert to sort of basic negotiation skills and sort of empowering people to properly negotiate in the workplace to resolve these interest disputes. And just to revert back to something you said earlier, I mean, what do employers do? Well, maybe that's something you do. You empower your workforce to be able to proactively engage in and realize the benefits of negotiation and or mediation in the context of resolving disputes. Anyway, that's my 2 cents worth.
Yeah, I also don't think you have much of a choice. I mean, I agree with Craig. In fact, to those that I advise, I always tell them, focus on the ones that are at plant level. Never be worried about what happens to the head office of the union. Your concern is always the ones that are with you. But I just have a question, Adil, and it's something that I'm thinking now, so I haven't applied my mind to it. Some unions, and I'll quote 2 as examples, PSA and IMATU, in their constitutions, they do not automatically go on strike. They have to ballot for a strike. Forget about what the Labor Relations Act says. So according to them, before they go on strike, they must ballot. I mean, we've seen now, I think from today, PSA is balloting its members in preparation of the public service strike. What I want to ask is, if legislation is letting us down, why are we not then, through internal dispute resolution, bringing in clauses through collective agreements that we think can assist the situation? Why are we not negotiating internally to have an advisory award before the union participates in a strike? I'm just asking, as I'm saying, I haven't thought about it. But surely the status of a collective agreement is worthy. I mean, why are we not? If legislation is failing us, we can't sit and wait for them. What is it that we are doing to save the situation ourselves?
So, Luvuyo, I think your question is somewhat rhetorical, but perhaps if I can venture some sort of an answer to that, I'm in agreement with your thought in that respect. So, where legislation is lagging behind, and in a particular industry, alternatively in a particular workplace, where an employer is able to see that it can get some gains through interest arbitration, advisory arbitration, whatever the alternate forms may be, prior to embarking on a strike or during the course of a strike, or whatever the situation may entail, does not preclude management in unions who want to take a long-term view in relation to a strategy on how to deal with industrial relations in the business to come to an agreement on that. The courts have certainly made it very clear the primacy of collective agreements is sacrosanct in our law. And if that's agreed upon between labor and management, the courts will give effect to it. So I think what's lacking, this is my 2 cents worth and my impression as I go along, is that as soon as wage negotiations are concluded, they kind of concluded, and life moves on because life is so busy. There isn't a step back in looking at, well, what do we need to do in relation to determining our strategy over the next 3, 5, 7, 10 years, or whatever the time period may be. And maybe that's another point to be looking at in relation to going back to the starting blocks, to say, well, is there a requirement for a reset in relation to collective bargaining strategies? Is there a requirement that the business looks at a reset because it's a post-COVID economy, a global recession, and a whole host of other difficulties that we're currently seeing, not only locally but globally, that we've got to reassess the situation and how we engage with our unions going forward.
Thanks, Imran. So let's just see, if you were sitting as the HR executive listening to this, or the group council listening to this discussion, apart from legislation, it requires us to engage with plant level employees in a trade union environment which is potentially fraught with concerns, but to invest money, effort, and time in order to build those relations with the one idea of them not embarking on violent strikes, but if they do, attempting to get them to agree to some sort of interest arbitration, otherwise use the various tactics available to them. I think from Luvuyo's side is that, from the chairperson of the ESC side, is at least from an employer perspective, one should certainly consider whether you fall within the concept of a support service within essential service, so that you can compel, from a legislative perspective, employees to embark on, well, this is not what he says, this is my view, just on the basis of support services, for people to be regarded as essential service, and then through the ESC's facilitation to determine some sort of minimum service, and then determine some sort of private arbitration. I think there's an interesting point made where they say that secret strike ballots should be made mandatory, because we know that they're not. But the question that I pose probably to Hugo, Craig, who have been practicing employment law for longer than most of us, is that doesn't the secret strike ballots and the balloting requirement take us back to the 56 Act and the issues that were fraught there, and trying to interdict strikes? And do we think that secret strike balloting is a way to sort out the sort of industrial conflict and industrial unrest? Hugo, Craig, Imran, the wheel of things.
My sense is probably not. If we accept, as we seem to, that the issue is fundamentally the relationships and the adversarial nature of them, I'm not sure that insisting on secret ballots is and sort of another layer of compliance, which introduces another sort of set of potential consequences and perhaps further conflict, is the way that we want to go. I just want to say one thing. It occurred to me while Imran was talking that if we're at the point where we're saying, well, you know, relationships are really the issue here, and we need to try and facilitate some kind of value-based relationship, or relationship by objectives, or some sort of joint exercise, whether a model like the sort of workplace forum isn't something that we need to reconsider. Not the statutory one, because that's been an abysmal failure in general terms, but my understanding, and perhaps Luvuyo can talk to this, is that the sort of local labour forums which are operative in local government have been quite helpful in terms of facilitating the conclusion of minimum service agreements. And whether it doesn't help a relationship for the parties to be able to sit down and in relation to fairly uncontroversial issues on a regular basis and engage hopefully constructively around those things, and thus use that as some kind of springboard to further facilitate the development of a healthier relationship going forward.
Thanks, Hugo. Sorry, Hugo, I'm not sure. Yeah, Hugo, you're on mute, yeah.
Apologies. So I can't agree with you more, and without sounding too old school, just a few comments, is that first prize is always a negotiated outcome. And we've genuinely seen, coming back to Imran's point, when we dealt with the issues during COVID, it was with the matured parties where people could sit around the table and say, jobs are at risk, let's come to an agreement with regard to suspension of whatever was in place in order to survive. But it worked. Outside of that, and I'm not talking about essential services, minimum services, those are in place, I'm talking outside that, we generally have this historic power imbalance. And unless we have that addressed, it's going to be difficult for parties to come to the table. And what have we seen in terms of that? We've only seen unions, and I'm giving you the employer's experience, is that they only come to the party with genuine wage negotiations, etc., if you've suspended the strike or if you've suspended the picketing and there's no alternatives, and on top of that you've addressed violence. And then once you're on the same sort of level, then there's scope for talk. But unfortunately, the reality is really, that's right, the violence is too much part of the union movement, and we can talk about that for hours. So I like a legislative amendment. Of course, we won't see it at this stage, and the question is whether it's even worthwhile discussing that within the next year or two, because we're not going to see that now, given the political landscape. But the answer lies in, and one doesn't want to go back to Thatcherism, but it lies in accountability of trade unions. The moment you touch somebody's pocket, they become accountable. Now, the moment they're not, or employers don't exercise their rights properly. But in order to get that, you need amendments in legislation and otherwise, and whether you have it by way of balloting or otherwise, because sadly, the other reality is many a times employees don't know what they're striking about. They're often misled by union leadership, or there's that political decision, as we've seen in NUMSA this year. So, yeah, first price, let's have a negotiated settlement, whether it's likely to take place, given what I've said earlier, unlikely now, but it doesn't mean we mustn't stop, keep on trying, because ultimately we want a solution, don't we?
Good. Thank you. We're coming to an end of our session. I'm just going to give all the speakers just a minute or so just for some concluding remarks. And Advocate Bono, maybe just start with you from the ESC. Thanks.
Thanks, Adil, and thanks for the opportunity. I just want to say two things, just in response to what Craig had just said. And you know, at the ESC, I took a very bold step in ensuring that there are MSAs. In municipalities where there are local labor forums, and some of those were dysfunctional. In most of those municipalities, I physically went and I asked parties just to sit for the purpose of an LNF. I mean, for the purpose of an MSA. And many of them listened to me and they said, we have MSAs in places that are not unionized. I ask employees to pick employee reps, and they have employee reps, and those employee reps sign on behalf of them, and we have an MSA. So I think a lot of what we do requires willpower. We have a lot of strike. There's some cleverness, or what Adil calls clever lawyering, that needs to give advice in terms of how we come out better in difficult situations. But in closing, thank you for the fruitful discussions, and I certainly think that I hope that I've given insightful information. At the ESC, we have many designations, so have a look at them, see whether you're in the value chain of anything that we offer, and speak to Adil. I'm sure he will take it from there. Ladies and gentlemen, thank you.
Thank you, Advocate Bono. Thank you kindly, and thank you for participating. Craig?
Thanks, thanks, Adil. Yeah, thanks very much for the opportunity. I found it a very interesting discussion, and I feel like we've barely touched on a number of things, and that any one of them in itself could be an afternoon's discussion. Again, it seems to be that we've come to the point where we're saying, well, we need to improve an industrial relations climate, and how does one do that? And we've considered various things, primarily the option of private arbitration or to resolve interest disputes in the private sector, and whether that might work and how that might work. I think that is one of the things that we could consider, but in addition to other things, apart from agreements. I like the idea that Imran mooted at drawing on international experience about making some kind of interest arbitration process compulsory if a strike gets to a certain point where it's considered no longer productive, or it's enduring too long, or whatever the criteria are. But that's something, and as Hugo said, I don't think we're going to get legislative change like that anytime soon. So yes, interest arbitration might be helpful. It might help facilitate better relationships. It might reduce the losses we might suffer due to extensive and violent strikes, but it's one of a battery of things we need to think about it. And ultimately, the aim is to try and boost these adversarial, or better these adversarial relationships in the various ways that we've mentioned. Thanks very much.
Thank you for lending us your expertise. You're most kind and always a willing participant and partner of the firm, so we really appreciate it.
You're welcome.
And finally, let's hear from Imran.
Thanks, Adil. Craig, Luvuyo, great chatting with you guys this afternoon. But perhaps can I round off with something anecdotal? A couple of years ago, I'd spoken at a conference, and we were speaking about collective bargaining in similar sort of topics, not interest arbitration, but collective bargaining just generally in different countries, and we were presenting in relation to what happens in the South African environment during the course of collective bargaining. And there was a delegation of labor lawyers from Germany who really, when we explained to them the levels of violence, intimidation, threats, burning of people's houses, petrol bombing and the like, stood up and said we were fibbing. There was absolutely no way that a strike could get that violent and people could lose their lives on the picket line. Not even the French were prepared to really believe what we were saying. So whilst it's become commonplace in South Africa that strikes are accompanied by violence, it's a sign of an abnormal society from which we all know we come. But it's not normal. A picket is meant to have a particular outcome in order to bring an employer to the table, and it really requires a change of mindset. And out of all of the negativity around COVID, I think it gives an opportunity, and I've seen it with some employers who sat around tables with unions to say we've got to reset our collective bargaining strategy in order to ensure the sustainability and viability of the enterprise going forward. And it's had some successes, not always, but small steps, and ultimately gets you in the right direction. So I'll leave it on that point, Adil. Thank you very much.
Thank you. To colleagues that have joined, thank you, and I trust that we have provided you with some insight as to how to deal with the industrial conflict that you are experiencing or about to experience during what is now colloquially called strike season. To the insight from the Essential Services Chairperson, to expert advice from our partner, Advocate Craig Bosch. We hope that you have benefited from this. This has been a longer than usual session for us. The recordings will be made available. They will be on social media. Should you require any assistance, just call your contact person at the firm. Thank you once again for joining us. Have a great afternoon, and as I say, enjoy the strike season. Cheers. Thanks. Bye.
Thanks. Bye-bye.